and also to, again, to our sponsors. You know, one of the nice things of having a sponsorship, obviously, is it permits us to do these kinds of things. But the other great thing about it is the fact that the participants think about where they're coming from, right? So you have Microsoft, a big established technology company, supporting this stuff. I don't speak for the company, and if you want to sort of have a sense of their interest in robotics, of course, you should talk to Elizabeth, who's here on there as a representative. But it's interesting to have a big, tech company involved and supportive, and then an international law firm, right? And invested in this as well. And finally, a trade association, which is the largest of unmanned aerial systems and unmanned vehicles, aerial and otherwise, participating. And I feel it really lends a layer and a legitimacy as well to the events. And then, of course, the Rock Center for Corporate Governance and Dan Siciliano, who hopefully you'll meet a little bit later today, have been extremely supportive. And then the Stanford Center for Internet and Society. So thanks, everybody. Okay, so I am really, really pleased to introduce these panelists here. So actually, Judge Karnow, I don't know if you know this, but like a lot of us sort of got into this field by reading your work and that of Larry Solom, right? And so you both had some really early interesting things to say about this when it was not on really anyone's radar. I mean, isn't that right? I mean, sort of, it was he and Larry and a couple, other people, and folks like Ian first and some of us later really got into this. And so we're really pleased to have you here, Judge Karnow, and we're really happy that you're thinking about this stuff again, or anew. And then we have a really wonderful commentator in Woody Barfield. Thanks so much for coming. And so, of course, you can take a look at their bios, but you'll see that Woody has training as an engineer, in law, and he's one of the people that is a truly interdisciplinary thinker about this space, and so we're really honored to have you here. And so with that, I'm going to turn it over to the panel, and thanks again.
Okay. Good morning. I'm going to kind of figure out what I'm doing as I'm doing it, if you don't mind. So Judge Karnow, I'd just like to emphasize a few points to his bio. The book he did that really interested and motivated a lot of people. I have it. It was published in 1997, and it's called Future Codes, Essays on Advanced Computer Technology and the Law. And it's a great book, and it's incredibly relevant for today. So the things that we're talking about, things that have been discussed yesterday, a lot of that is in that book. And of course, if he did the book in 97, he was thinking about the issues far earlier than that. So he's truly one of the original people doing work in this area. So it's great that he's here, and it's really great to be presenting his paper and commenting on it. I don't have a PowerPoint. I should have a PowerPoint. I always do PowerPoints. Common ex-faculty. I mean, I do PowerPoints in my sleep, but about 20 years ago, I did stuff with posters, and I thought, what would Stanford want more than anything in the world? And I thought, they'd want posters, of course, so I have some. And since I know you can't see them in the back, I'll explain them to you. So, use your imagination, we'll get along fine. Robots and law, and what's some motivation for applying tort law, which is what we're talking about, to robots? Well, robots harm and kill people sometimes. So that's happening now. And when that happens, what's a good legal theory to apply? And of course, tort law is a good legal theory to apply. There's, I think, a company up in Sunnyvale or down in Sunnyvale, whichever direction, the Da Vinci surgical simulator. And if you go online and Google that, you're going to see lots and lots of, you're going to see some malpractice suits, you're going to see some lawsuits, and you're going to see a whole list of injuries that are happening to people as a function of that surgical simulator. So I think that's very interesting. So part of this conference has getting down to business in the title. And so when I first saw that, I thought, well, I'm going to go there and I'm going to roll up my sleeves and I'm going to get down to business. But there's actually, it does actually mean business. And so a different kind of business. So in terms of business, we think about robots, so we think about technology and so on. I kind of think about who's working and who's not working and why. And a lot of the things we used to do manually, we don't do anymore because technology does it now. And it seems that artificial intelligence and smart things are moving into the field of intellectual endeavors. And so I wonder where things are going. But in the retail and service industries, 20% of people employed in the United States are in that industry. And there's a lot of robots that are coming online now or planned for the next 5, 6, 7, 8 years that are going to start doing the things that 20% of our population does. So that's business. So I want to tie it all back into business. All right, so I'll come down here and I'll try to go over one of my posters. And I know that, like I said, that unless your vision's a lot better than mine, you probably can't see everything. This is the largest I could find when I went over to Staples. But I'm going to just lay out Judge Karnow's paradigm. And it looks like this. Imagine this is the line that represents input and output. And here on the input side, we have a human. And that person is providing directions to a robot. He's telling the robot what to do. He's the person telling what the task is, what the goal is, what you should be doing, what you want to solve. And then we have something that I call it Karnow's interesting robots. He describes these robots as interesting. And I want to give him credit. I'm going to make him famous. Karnow's interesting robots. Forevermore, that's the way we'll talk about them. Okay, so what are interesting robots from his point of view? Well, they're robots that can learn. They're robots that can self-program. They use nice heuristics such as genetic algorithms. And they have the ability to organize their own software, organize their own hardware. And the interesting thing about Karnow's interesting robots is what I wrote in red, which is they engage in unpredictable behavior to solve a problem. So if you're thinking about tort theory, if something is happening and is predictable, that has implications for tort theory. If something's happening that it's unpredictable, that also has implications for tort theory. So his type of robots that he's talking about engage in unpredictable behavior, and that's incredibly important. So the output over here, there could be multiple outputs, but one output could potentially be a harm to a person or property. And if that were to happen, that's where the law of torts gets involved. And there are two major tort theories that we may be interested in applying, the law of negligence and the law of strict liability. This is basic paradigm. And again, interesting robots. They're interesting because they can program themselves. They can learn. They can do things that other robots don't do. So I'll just throw it down there. I don't have very many of these. Okay. Well, one thing I like about his paper and his ideas is that he puts things on he creates a continuum of autonomy. So these are a continuum of autonomous robots from low to high. And on this end, we can put uninteresting robots. They're not uninteresting for any reason other than the fact that they're not really smart. They're not very smart. They're uninteresting because what they do can be predicted. And I drew the little squiggly line. On this side are Karnow's interesting robots, again. And they engage in unpredictable behavior, as I mentioned. And I just went ahead and I drew another squiggly line, and I put the 800-pound gorilla, which is Kurzweil's robots, if we ever get to the singularity and beyond. So that's not something that he discusses, but I think since we're drawing a level of a continuum that relates to autonomy, I thought I'd throw that in. So. Okay, so so here again we have this continuum of autonomy. Here we have the uninteresting robots. Here we have Karnow's interesting robots. And here we have tort liability. And in tort liability, we're really interested in focusing on whether, the risk or the harm to a group of plaintiffs was foreseeable or not. And if you think about the interesting and uninteresting continuum of robots, you can start to think that foreseeability might apply to one group, but not the other. So to give you one of his conclusions is that negligence does apply, and all the standard rules of negligence applies to uninteresting robots because what they do is predictable. And so they're covered by tort law. And again, I'm just providing you kind of a thumbnail sketch or a framework for his paper, and then he's gonna provide some more detail here and there. So here we have the continuum again: autonomous robots, uninteresting, interesting, and I've written down strict liability because that's something he discusses in a lot of detail in his paper. And there are different types of strict liability. And we have ultra-hazardous activities. We have different types of product liability. I think these things came up yesterday as well. But failure to warn, design defect, and manufacturing defects, different types of torts. Well, strict product liability. And in all of these product liability situations, foreseeability is an element. So foreseeable plaintiffs, type of harm, and the manner in which the harm occurs. So again, think about foreseeability and these elements, and do they apply to uninteresting robots? Can they possibly apply to interesting robots? So, well, back here. That's my high-tech presentation. So again, so he talks about the type of robots that he talks about are, he refers to them as embedded machine intelligence. And by that he means that you've got a robot, it's got software. The software does all kinds of interesting and smart things, and that's the embedded system interacting with the complex environment that he's talking about. One of his main points is that autonomous robots devise their own means to solve problems, and therefore they may not be subject to liability under current tort theories. And in kind of a conclusion, he looks at autonomous smart robots, and he poses the question: how could we potentially account for their behavior and maybe pull them in under tort law? And so one way we can look at the robot, and he mentions we can look at the human. From the robot point of view, he argues that we should in some way constrain their behavior by common sense. So in other words, if the smart robots were doing things that you and I do with common sense, then what they do is predictable. Because if somebody does something with common sense, it's something that's expected. And if it's expected, if it's predictable, then possibly it's foreseeable, and maybe not tort law then that would be an element that would be exist in tort law. And the other thing is that he argues that humans should actually gain, from the human side, we should gain more experience. If we have more experience interacting with smart robots, then we'll be better able to predict their behavior. And if you can predict what something's doing, maybe it's foreseeable, maybe tort law applies. Okay, so two things I particularly liked about his paper. One was the idea of placing a robot and its capabilities on one axis, and then essentially looking at law and the elements of law on another axis, and kind of seeing where they match. And the extent to which they match is basically a measure of whether the law applies or not. And so I think that kind of thinking, that's my second point, I think it's a great methodology. I think that methodology could be used not only for tort law, but for lots of other laws that you might want to apply to intelligent things such as robots. So again, the continuum in which you have the robot capabilities, what it can do, its ranges of motion, degrees of freedom, maybe the control theory models that are guiding it, things like that. And you have the law, and law, it's codified, we know what the elements are, and we see whether we can match those or not, and we'd know whether or not the law applies to that intelligent being. And with that, I'd like to turn it over to Judge Karnow.
Well, thank you. How's the sound system working? Okay? Wonderful to be here. I'm really very grateful to the invitation, and thank you to Woody, who has spent an enormous amount of time on a paper. I hope it was worth it. My guess is that most of you have not actually read the paper. So what I'm going to do is three things this morning. First, I'm going to give you, just in about a minute or so, just a very fast outline of the paper. Then I'm going to suggest the 3 or 4 points that I think are not new to the paper, but are the major points of the paper, which I hope have some novelty to them. And then finally, a couple of problems with the paper, some of its weaknesses, And lastly, an area which I think is extremely interesting for further work, not for the technologists among us, but perhaps those who are interested in the law, further work and more thinking that we need to do in this area. The basic outline of the paper, well, first of all, Ed, I have to give one caveat. I don't have my judge hat on today, so anything I say is not a comment on any pending or impending case, and you can't tell anything about how I or any other judge would rule on any case based on anything that I say or anything that I even hear. So that's the caveat. I'm playing hooky today, and I'm here to have some fun with you and talk about some really interesting issues outside of the office. The basic outline of the paper is this, that it talks about, what Woody's talked about is interesting robots. So I try to have a definition of interesting robots, and I use the term autonomy. A lot of people have written about autonomy and what that means, and it means something profoundly different in a lot of different sorts of contexts. There are moral connotations to it. There are a lot of other connotations to it, but I try to give a working definition of autonomy as machine intelligence which is devising its own path, which is inventing its own heuristic. And I go back and talk a little bit about some of the 1975 work that John Holland and other people were doing with recombinant code and so on. So I talk about that, and I try to come up with this working definition of interesting or autonomous machines. I talk about self-learning and self-teaching and give a brief look at some of the technology that is being cooked up today. I talk about how increasingly embodied machines, that is machines that are in a physical embodiment or interacting with the world, create a larger system, a system which is composed of the environment that they are sensing and touching and manipulating, plus its internal states and its software. So that's what I mean by embodied. And then I take a break and I talk about the law, and I bring people up to speed on things which the lawyers in the room don't need to be brought up to speed on, but I talk about tort law, what it is, where it fits into a larger spectrum. I talk about negligence, what it is, and then strict liability, the four theories of law that are usually comprehended by strict liability. And I conclude from all of that that all of those things have in common this notion of foreseeability. We don't punish people under the civil law. We don't impose liability on people under the civil law unless what they've done is something which has caused injury which is foreseeable. And it's a fairly limited scope of events which are foreseeable. So it's foreseeable type of injury to foreseeable types of victims. So it may be foreseeable when you drop a match on the floor, for example, that the floor might light on fire, but it's not foreseeable perhaps that some weird series of events will occur. Somebody trips on the match, falls down, breaks their nose, and as a result doesn't get the job in the next reality TV show. Are you liable for the loss of earnings for the reality TV show? That's probably not going to be, quote, foreseeable. So I go into what foreseeability is, which when all is said and done is a fairly constrained group of future events which could be considered to be foreseeable. And I suggest that all of tort law, one way or another, requires that kind of foreseeability. Having done that, then the paper jumps back into the issues of foreseeability when it comes to robots. And of course, I've teed the whole thing up, so now you've got a big discrepancy between the types of unforeseeable results that embodied intelligences are responsible for versus the law that can't handle that because those events are by definition unforeseeable. So that disjunction between what robots are going to be programming themselves to do, which is by definition unforeseeable, and the foreseeability requirements under tort law creates the interesting problem. But it's only interesting in a very, very limited group of situations. Most of the things that we call robots are not at all interesting in this context at all. 99% of what's going on out there, these robots are doing completely foreseeable things, or things that maybe are not literally foreseeable, but ought to have been foreseen by the operator, which counts as foreseeable. So all of the tethered robots, the Mars rovers, even the missile systems, the Aegis missile system on Navy carriers, and heat-seeking missiles, the AMRAAM, which is a radar-guided cruise missiles. I mean, all of these things are utterly and completely programmed, and their consequences are completely and utterly foreseeable. So none of those things, from the perspective of this paper, are interesting. They're interesting for other reasons. And for the same reason, drones, at least the drones that we read about in the newspaper, those sorts of drones, even if they kill people, are not at all interesting in the context of this particular paper. So that's really where the paper goes, and it ends up talking about how we may accommodate ourselves to the machines and vice versa at the end, and I'll get to that in just a moment. So that's the basic outline of the paper. What's new, I think, in this article, or interesting in this article, is the first thing, which is its slightly more rigorous definition of what interesting or autonomous is than I've seen in other papers, so I can tee up what the argument that goes on after that. So that's the first thing I think the paper does, which is interesting. The second is I emphasize the embodied nature of machine intelligence, and I do that because I think real learning in the sense that we care about, machines learning on their own, can only happen in the world. It can only happen in the physical context. Keeping it in the laboratory isn't going to work. There are a lot of experiments, a lot of work that's being done with simulated environments, obviously, on the computer, where things are handling a simulated environment. But those are so unidimensional, it's not going to lead to any real learning. So the only way machines are going to learn is to be out in the world and be able to literally run into it and have that experience. By the same token, I think that's the only way in which machines are going to learn common sense. Yes, there's a lot of great work being done on the databases about rules about how the world works and things that should be associated with each other, and if you see this, then remember that, and all that kind of stuff. And some of those databases are now extremely large and very nifty to look at and play with, but that's only the beginning of what machines need to know. They can only learn on their own in the physical world, so these have to be embodied machine intelligences. The third thing that I point out is to, and this is where I think some of the future work can be done, is I distinguish between current tort law, which is Newtonian, if you will. It's the billiard ball approach to what causes what. So in current law, all the way up through today, really, there's not a lot of imagination going on about how things happen, how things occur. We have this view of one car crashing into another car, causing somebody's leg to be broken, and that's 99% of the work, that I do in court. I mean, we have people with a broken leg in that sense, where you have one linear route of causation. Now, we can accommodate multiple routes. We can accommodate two people crashing into each other and all being responsible, plus the tire manufacturer is also responsible because the tire blew. And so we can accommodate situations in which, through comparative fault, we have 20% fault here, 20% fault there, 60% fault here. We can do that, but these are still very Newtonian sort of systems that we're talking about, and the law right now can only accommodate these sorts of systems. But the truth is, as this paper, I think, points out, is that the truth is that bad things happen as a result of very complex interactions from a wide variety of sources. And causation is a really complicated, really interesting issue. It's a complex issue, to be technical about it. And the law doesn't know how to think hard about those issues. And this case with the unpredictable behavior of machines is one example. Some of you maybe have read Charles Perrow's work on complex systems and what he calls normal accidents, when everything predictable happens, but still two things collide and blow up and explode. Nuclear reactors, two ships crashing into each other on the ocean or something like that. So the issue of how to deal with complex systems and how to talk about causation in complex systems, I think, is some of the future work that we want to do. It occurs in the asbestos case. Anybody who's read a lot of the cases in asbestos will understand how complicated asbestos causation is. And it's a subset of exposure, of environmental exposure, and how complicated it is to try to figure out why somebody got a disease. The BP oil spill, perhaps. A lot of securities law and antitrust cases have extremely complex systems which have generated the bad result, and yet we're holding certain individuals liable for that bad result. So this is where I think a lot of the work can be done in the future in terms of trying to get the law to understand how to ascribe liability when you have complex causation issues. There are at least 4 problems with the paper, or 4 weaknesses with the paper, which I would be delighted to have people discuss and give ideas on if people are in the mood to do it. The first problem, I think, is this. What is it to say that machines or that software learns? What does it mean, really, for software to come up with its own heuristic. I passed by that fairly quickly in the paper in about a paragraph or so. And I'm making a lot of assumptions about what it is for machine intelligence to learn on its own, or to learn in an unpredictable way, or in a way that is not prescribed by a human. It probably means a lot of different things, but it's a kind of a little ellipsis which I move very quickly across in the paper. Secondly, what's not analyzed in any detail in the paper is what's the relationship between complex systems, classic, I shouldn't use the word classic, but between what we now know as complex systems and self-teaching software. What is that relationship? A lot of people have written about it, but in a very sort of gloss. A lot of people, including myself, sort of gloss over off that issue. Thirdly, something which is not discussed at all in this paper, and given my day job, I probably can't discuss it, although the issue is interesting, is what are the policy recommendations? What new laws or new legal regimes would be useful if tort law, classic tort law right now, doesn't work for what we call interesting robots? New insurance schemes, new policies, new regulations, or none, perhaps, arguably none. And if you look at footnote 4 of the paper, you'll see there are some people who believe that we ought to have none, or we ought to have a hiatus in the application of tort law, and others who believe that that gap has to be covered by new rules. And then finally, just technologically, what's going on in terms of autonomous robots? What is actually happening out there today in the labs at Stanford and other places where people are working on self-teaching machines that they can kind of, if you will, the clockmaker view, you can wind it up and let it go. And when it comes back to you 2 years later, aha, marvelous, something superb has happened. The machine now knows how to do things that we never realized it would be able to learn how to do. What's really going on there? That would be interesting as well. So that's just a very quick overview of the paper, quick overview of some of the points it tries to make, and some of the gaps in the paper that might be interesting. Is this a Q&A session or comment session? People want to talk about other issues? Privacy.
I have a question. Steve Wu from Korik & Wu. I had thought, as you did, about this problem of robots having to learn things. And as you, in yesteryear, I was thinking about how machines are going to have to come to learn things on their own, and this experiential process is going to help them eventually get to a point of competence over time in terms of living in society. And then I thought about the big data phenomenon. And I just wonder if the big data phenomenon and all the data that could be fed to robots to have robots share experiences may really accelerate the learning curve. Do you see that as really changing the equation in terms of the uptake of intelligence?
Well, I'll comment first. I mean, it's all out there, but the world is out there too. And the problem with big data, if you will, is that it's all been, in a sense, it's been processed. I mean, somebody has pulled this information in, and it's been structured in a certain way. So you've got initially just a problem where you've already got an abstraction of the world. And I think every time you abstract the world, you're taking away from the learning opportunities that could be available to machines. Now, I'm not talking about the dangers. I mean, obviously putting machines learning on their own, bad things can happen, just the way a 5-year-old might bite somebody or something like that in the playground. We don't want to see that. Yeah, I think it can happen. You've really made 2 points. One is that amount of information going to be useful? Big data alone is unstructured. So the links have to be made, and now that's their second level of abstraction. So you're abstracting and abstracting before you get to something which is useful. So I don't know. That may be part of it, but it won't replace actually learning through experience. The second point that's been made with that comment is, how about sharing? And that's something else. I mean, there are lessons, and if you, just like crowdsourcing, 200 million people doing something is going to be a lot more efficient than one entity doing something. So if people could actually build systems that talk to each other, sometimes I think companies are going out of their way to build systems that refuse to talk to each other, that would probably be very helpful. Woody?
Well, I just want to ask you a question following on that. I mean, if you have a particular robot and it has a particular software mind, so to speak, and engages in harmful behavior, you have to think about how tort law applies to that. But what if there's some more, what you were mentioning, a distributed intelligence, where you really can't attribute it to just, so to speak, one mind, but many minds? I mean, how does that complicate things? What do you think about that?
Oh boy, I love it. I mean, I love the image. I really don't know really what to say. I mean, I think the issue of distributed responsibility is sort of a separate issue, and it just makes things a little bit more difficult in terms of the complex system. It's just what you've painted is just another way of sort of thinking through what I've called in the paper sort of the large system. So, there are people who are programming, there are people who are implementing, there are people who are using, there are customers. You've got a whole bunch of people who are involved in the use of a robot, somebody who is permitting the robot to be on their land. So the law can look at the responsibility and can look at a whole number of different players who could be involved in having some responsibility for a bad act. And in fact, it's the job of plaintiffs' attorneys, and I used to be a plaintiff's class action lawyer in the late 70s and the early 80s. The job of a class action plaintiff's lawyer is to find as many people as possible who might conceivably have some liability for a bad event, and then sue them all, and sue them all and let God sort it out, as the T-shirt says, or let the litigation system sort it out. So that's their job, and so when you have a regime in which there are a lot of people who have potential liability for an act, the temptation is going to be to sort of bring them all in and let them sort it all out.
Contributory negligence or whatever, as a function of a subroutine, you've got to pay 20%.
Everybody has 1%.
That subroutine has to
40%. Let them fight it out. Exactly. And this happens all the time. Asbestos is a great example where you can have a person who, through his life age, the person is 75 years old, through their life they've gone through 42,000 different workplaces with potential exposure, and different kinds. People who had the premise, they get sued. People who permitted the exposure to occur, they get sued. The people who were there a year before but left some dust on the floor, they get sued. The people who built the house, they get sued. The Navy can't sue the Navy because of sovereign immunity problems, but they're responsible as well because the guy was on a submarine. So, there are a lot of legal regimes, and this is, I think, the future work to be done. There are a lot of legal regimes where it's actually a very complicated, highly distributed series of entities that could conceivably have some causal role in what ultimately becomes the injury or the damage. And the question is, how does the legal system either bring these people in and distribute liability
across many jurisdictions.
Or not? Yes, and you're right. Some of these people are in Alabama, some of them are in France, and some of them are in India.
Yeah, maybe we should move on to another question.
All right, this is a really interesting topic. Wanted to follow up on this idea in the paper of potentially strict liability theories being applied, and whether the current strict liability theories, design defect, manufacturing defect, failure to warn, don't adequately match this future of maybe autonomous robots, and whether if strict liability is an appropriate framework to help internalize these risks, whether some new theories need to evolve to adapt to this situation.
I'm sorry, what's the question?
Oh, the question is, do you think that if the current theories of strict liability don't match the situation where we have these interesting...
And what
robots,
does?
Yeah, right. Do we need a new theory developed, legal theory?
Well, as I said, these new policy issues are a little bit above my pay grade. My job is to just enforce the law, whatever it is. But putting that aside, the problem is you've got some policy problems. Before you start moving, you have to decide how much regimentation do you want to have here. The law moves fairly slowly, and so you're probably not going to get, unless somebody does some really nifty work in what I call complex causation, and maybe that'll be my next paper, and there may be other people writing about that, but generally speaking, the law right now with respect to strict liability and negligence requires foreseeability before anybody can be found liable. So with respect to interesting robots, it does not work. You can't apply it. So if you want to move past that, you're probably not going to get it from the courts, because the courts move slowly and judges don't want to be thought of as making new law. So that means that you have to go to the legislature. You have to go to a lawmaking body and make policy decisions about what kind of liability you're going to impose. Now, there are ways to do it. We now have this thing called insurance. So people who are involved and are foreseeably involved in the utilization of robots, there are ways to spread out the issue. And one of my papers in Future Codes talks about the use of insurance to take care of autonomous intelligence, the actions of autonomous intelligence. So there are ways to distribute the cost. Probably my wife, but she knows where I am, I told her. Excuse me, that I don't work for the White House and I don't really have to answer that phone. So the legislature will have to make policy decisions about the extent to which they want to do that. The other answer to your question is, where do we go, is the last 2 pages of this article. So the last 2 pages of this article suggest that we in the law have the ability to look back and pretend that we saw it coming all the time. This happens a lot, hindsight bias. So this happens in lawsuits today, where something happened to somebody, it was a bad thing, they got injured, the actors are sued, the plaintiff is able to say, look, you see what happened? That was foreseeable. In other words, using hindsight bias, 20/20 hindsight. And so we already have techniques, these are psychological fallacies perhaps, but they are techniques to sort of look back in time and say that this stuff was foreseeable all along, so we can keep the system going and compensate people who get injured. And then finally, the other note in the paper is that it may well be that machines will start clustering in the frequency of their actions. That is, that we will in fact see patterns emerging from behavior. This will take time, years, before this starts happening, where human beings look at the behavior of autonomous robots and start learning from them. We can learn from them, and we see how it works out. At that point, we get charged with knowledge. We get charged with foreseeability. We can now foresee things. So those are the 3 answers, I think.
Thank you.
I have a thought as well. I mean, so wouldn't it be interesting if we have the group of so-called uninteresting robots, not interesting for any reason, any bad reason. Tort theories apply. Karnow's interesting robots, difficulty applying foreseeability. Then they get, so it's questionable whether tort theory applies. Then you move on to the continuum, and all of a sudden they get smarter, and we attribute, enough intelligence to them that they know what they're doing. Tort theory applies again. So we could have it apply, not apply, apply on that continuum.
That's a nice picture. Sir.
So first, thank you for that middle section for us non-lawyers. Between the 8 papers, I almost feel smart enough to ask a question. So appreciate you putting that part in. I like how you called things interesting and uninteresting. I think you played that well through the paper. A couple of thoughts. On my side, I really read it as deterministic systems versus non-deterministic systems. Aegis, in the end, is a deterministic system, right? You can follow the lines of code and if A, then B type of things. And what you're talking about is sometimes if A, then B, and other times if A, then C. So one thing to consider, I don't really have a question on this side, is are those outputs bounded, or do they need to be bounded? So it can be A, B, C, or D, right? But only those. There's no such thing as E or F on that side. So that's one thing to think about. Another thing you asked about what cool stuff is going on in this area. I point to my favorite group is the Neuroscience Institute.
Could you say it one more time?
The Neuroscience Institute out in San Diego, nsi.edu. They did some cool stuff with robots. Their goal is to understand the brain, but they've got this great experiment where they do what's called the Morris, M-O-R-R-I-S, water experiment with a robot and show that an artificial hippocampus can actually learn and do the same experiment as a mouse. Fascinating stuff about whether humans are actually deterministic versus non-deterministic systems. So my question is this, is even with a deterministic system, right, so even an Aegis type of system, well, it's taking away war. Even if I have a robot that's deterministic, if I'm relying on third-party software or cloud type of things that says, this is a microphone, and it comes back and says, no, 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 this is actually a potato, and I built my robot to kill all potatoes, I'm going to kill this microphone. So how does that third-party side, right, that may be non-deterministic or may be interesting in that sense, apply to what is relatively an uninteresting robot?
So are you painting a picture in which you've got, let's make it up, 10 contributors to the ultimate system, and that's the problem? In other words, you've got people who are making hardware, you've got people who are making the operating system, you're having people who are making middleware, you're having people who are making the top software, and your concern is how do you distribute liability among all of these folks? Or
does that really, I mean, is that, yeah, in some sense, yes. Let's go with that.
Yeah. I mean, I think that's just, people are kind of, I think what's going on, and it's sort of interesting, are people are restating the problem again and again. In other words, people are pointing out through these comments that however you want to slice into it, you have a kind of a wide spectrum of people who are potentially liable, people who have made things without any expectation of what the ultimate result is going to be. I mean, it's like blaming Microsoft for making Windows, 8 when somebody uses a robot to, drive a car and crash into something. So, I mean, I don't know what to say. I mean, it's true. This is distributed, and people are going to be using things from a wide variety of people. But let me ask you a question based on the work that you're doing with respect to machine learning and human learning and robot learning. Do you think that the lessons that one gets from human learning are the sorts of things that we can apply to machine learning, or is machine learning just a coincidence that we're using the same word, quote, learning? In other words, there are studies, of course, everybody, has an opinion as to how human beings learn things. Children, adults, there's an entire industry of 22 billion people who are engaged in how humans learn. My question is, do you think those lessons are applicable to how robots would learn, or how artificial intelligence, quote, learns, or is it a completely different?
There's different camps.
Yeah.
I will say that, and I'm not an expert on either camp. But I was very disenchanted with artificial intelligence when I took it in undergrad, as I realized a lot of AI is just search theory, right? Isn't something magical. There's nothing magical about Watson. It's just pure search theory, and the same thing on the chess side. And then there's the other side, and the Neuroscience Institute guys are on the other side of trying to do that bottom-up neuromodeling and trying to understand how the human brain works, and using a robot as kind of a synthetic human brain. Since you can't watch every single neuron in your head, you can synthetically create that through a bunch of computer programs and then try to understand what the human does on that side.
Right.
So there's very different camps. I love the Neuroscience Institute guys. If it'll actually ever apply is debatable.
Yeah. Yes, this has been going on about 30, 40 years as to what learning actually means in this context.
Let's move on to Ian Kerr. And by the way, he teaches 2 interesting courses. Ian is over there. One is called The Law of Robots. The other one is called Building Better Humans. So, with that introduction.
Well, thank you very much for the introduction, Woody. And I did want to introduce myself to Justice Karnow and expand first for a moment on Ryan's comments. I'm one of the people like Ryan. I remember the early part of my career, the skyrockets that went off in my head in 1998. When I was asked by the Law Commission of Canada to answer the question whether computers could enter into contracts. And I turned to your work and to the work of Lawrence Solomon and tried to sort of propose a framework that engaged and invoked existing legal principles to propositions that were at least near or midterm ways away in terms of the technology. And I think it's fair to say what Ryan said, which is that your paper was not only seminal, but really inspired what I think we're trying to cultivate here, which is a field. So I just wanted to start by thanking you for that, as Ryan did already. Really, really appreciate and admire your work that you did then. And I'm also really gratified to see that, like me, those questions continue to linger for you, despite all of the things that you're doing in your career. So I think that's both gratifying and fantastic. Just a quick anecdote in terms of my own proposals, because you had posed several questions to the audience about the kinds of things we might think about. In the contractual setting, one of the things that I was really attracted to back in my early work in 1999 on this, I wrote a paper called Spirits in the Material World, and it was about contracting bots. And one of the things that intrigued me was that the law of agency provided some really good anchor points for thinking through how we might think of the world that we're only now starting to call co-robotics, where humans and robots or artificial intelligence systems are interacting together to produce effects that couldn't be done without either of those components. And what attracted me to that theory, and I won't get into too much detail in the work itself, but what attracted me to that theory was in part based on the recognition to me that we not only probably would need principles of liability, which is what you're sort of more focused on in this current work, but we'd also need principles that to some extent contracted or shrunk liability. And it seemed to me that the idea that in agency law, number one, the agent did not have to have legal capacity. You could send a child to the store to buy your milk. In ancient Rome, you could send a slave into the marketplace to do your bidding, and yet you could still conceive of a transaction that tied the agent back to the principal. It seemed to me workable from that perspective, but also workable from the perspective that when it comes to certain questions of liability, there's room within agency law to say, you know, we can detach the principal from what the agent is doing for various reasons, and in other situations attach them. So it's not necessarily relevant to some of the scenarios that you're contemplating in your work, but that was my original contribution. Skipping forward, you know, more than a decade now to where we are now. Last year at We Robot, one of the topics that I was very interested in and made a contribution in was where we're heading in terms of co-robotics in certain fields like medicine and law, where more and more we're able to use artificial intelligence systems to do what the lawyer or the doctor couldn't do on their own. And so IBM has probably made the biggest splash when Watson changed professions from winning at Jeopardy to becoming a physician diagnosing cancer. But the question is a long lead up to a question that I'm really interested in your take on, which is for some of those kinds of co-robotic endeavors, they take place in an experimental setting where the underlying premise is that the human expert really is at a loss for what to do. What they're about to engage in terms of decision making is speculative for sure, and often set in an experimental setting. So nobody knows for sure whether a particular emerging treatment might be the right cancer treatment. But then what we imagine in the robotics scenario is a situation where Dr. Watson actually starts to outperform the human doctor. And to the point where the approach in medicine, which is based on evidence-based reasoning, is such that we actually now have good reason to delegate the task to Dr. Watson, because Dr. Watson, let's imagine, has a better performance record and just does better at this task than the human doctor. But we also imagine that the human doctor is still left in the loop and is often faced in these sort of Hamlet-like dilemmas in terms of, do I follow the advice of Dr. Watson when my own ideas might be to the contrary, but Dr. Watson seems to perform better than me. And so we'll get into all sorts of really interesting scenarios. I guess I'm wondering, and my question is about whether the way you're thinking about liability in these current schemes can contribute to how we would resolve those sorts of situations where the whole premise is that the kind of activity that the robot would engage in is speculative to begin with. So often patients don't hold their doctors accountable when they're engaged in experimental therapy, when they sign on to that. I'm just wondering if you have any comments on that scenario, because I've been thinking about it for a year, and I'd just love your take on it. Thank you.
Well, the rule one, at least for people in my job, is to do everything possible to push the new scenario into an old into an old bucket, as it were. So if it is at all possible to think about these things under traditional theories, then we will, and courts will, and judges will, and things like that. So the question is, what's really going on with, for example, the use of machines in medicine? Now, aside from the product that you were talking about, which is, I think, is the Da Vinci operating machine, you're talking about a diagnosis issue. And I think it's, my tendency is to try to simplify everything. So that's everything I do is, I'm in a department called complex litigation in San Francisco. And the job of complex litigation is to simplify. That's the main job of what I do. So to simplify your scenario, I say I map the following, which is that the Watson and other techniques are simply being used to give ideas to a human being. And the human being is making the ultimate decision as to whether this is really pancreatic cancer or not, or something else. So what's hard for humans to do is to think of the 42,000 things that could be wrong with this person. I had malaria, and nobody could figure out that I had malaria for about 4 or 5 days, which was a very bad 4 or 5 days. Nobody could figure it out because I was in the wrong country, and there is no malaria in that country. So it would have been great to have Watson look at me and say, you know, have you thought about malaria? Because the minute that came out, everybody went, duh. So that's what that's what machines are doing now, I think, in the picture that you painted. And in a sense, that's not interesting. I don't mean that in a personal way. I mean it in the way that Woody was talking about earlier. Because the humans are getting ideas, they're looking at it, and they're saying, you know, that actually is malaria. And they're making the decision process. So there isn't any sort of liability issue there. And if the doctor's wrong, the doctor will get sued for malpractice, and rightfully so, in the same way the doctor who relied on any other technology but got it wrong could get sued. So the decision-making there is still, you know, there's diagnosis and there are ideas and things that are getting presented to a human, but then the human ultimately is making the decision. It's the same thing with the Aegis missile system, which is a defense system used by the United States Navy and a number of allied navies, where people talk about, or the rhetoric about this missile system is that it's a you know, it makes up its own decisions as to who to attack or something like this, and that anybody within a radius of X miles gets targeted and destroyed. You know, all you have to do is sit back and smoke a cigar. It's completely false. That's not at all how the missile system works. Humans designate what the targets are going to be, and the human commands the missile to do whatever it needs to do to take out that target. And the problem way back when a civilian airliner was taken out by mistake, it was a human problem. It was not a computer problem. It was a human problem. The captain of the ship didn't understand what was going on, and they designated the wrong target and took it down. So, you know, that's, I think, a comment there. The other issue about agency, and I know it's a little bit out of our scope, and we're getting to almost 10 o'clock, so I'll keep this to just less than 1 minute, is I think you're right about agency in the sense that you can use agency law to pull in these extensions so that they become the act of the principal, the human or the corporate principal. Both corporations and humans, of course, can be principals for their agents. But you still have the issue of scope. So as you think through how agency law is going to apply, you have to think whether the agent, whether it's software or a child or a slave or whatever it might be, whether that agent was acting within the scope of the agency. And once you do that, then you do step right back in to the morass that I talk about in my paper, because that sense of scope, that sense of what we sent the agent out to do. I sent the agent out to go get bubble gum. It ended up, you know, taking a toy from a small child instead. Was that within the scope of the agency or something like that? You'll get to those foreseeability issues, and I think that could be a really interesting place to go.
Maybe we can get a couple of quick questions. If you can pose your question kind of quickly, you can.
Definitely, really quickly. So I'm thinking a lot about how distributed intelligence is probably where a lot of these interesting robots and interesting systems are going to come from. And there's very few areas of the law where we really do think about effectively distributed systems, except for criminal racketeering. Potentially, could RICO be a model, and not necessarily a good one, but for how we start applying distributed liability to distributed systems?
I don't think RICO is the racketeering law is all that helpful, or let's put it this way, it's no more helpful than common conspiracy law. So RICO, for those of you who are not intimately familiar, and I used to be a federal prosecutor, I had a lot of good times with RICO, had a lot of fun with that. as I did with conspiracy law, because under federal law, you can be convicted of conspiracy and it's punishable up to 5 years, even if you haven't done anything than just agreed to do something with somebody, even if you didn't do anything on your own. So it's pretty nifty from a prosecutor's point of view. But what's common to both RICO and common law conspiracy and statutory conspiracy is that you have to have groups of actors, people who themselves are legal entities, people or corporations. So right now, only people and corporations, I'm mushing it just a little bit, can be tagged with liability under the racketeering laws and the conspiracy laws. And RICO is just really kind of a big fancy way to talk about conspiracy law. It's got a couple of other bells and whistles which allow increased penalties and allow other things to happen. So it doesn't avoid the problem. I mean, you still have to go out and say, here are legally responsible actors who themselves could have been convicted of a crime on their own if they had done this, if they had done the money laundering or something like this. Yeah, so all you can do under these laws, you can only get human beings. And the issues of foreseeability, or whether they should be liable for the bad act that occurred, it doesn't go away. It hasn't gone away yet.
One of these conversations that I really hate to cut short because it's been so absolutely fascinating. Judge Karnow, will you stick around for a little bit at least?
I'll be happy to. I don't want to go back to work. I'd rather stay here.
So ask him lots of questions during the break so he doesn't have to go back to work. I think that seems like a fair trade. Thank you so much for coming, and thanks, Woody, for your great commentary. Appreciate it.
Thank you very much.
Thanks so much.